Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Hey everyone, I forgot my intro again. So hello. Welcome back to J is for Justice. My name is Jay. I am your host. We are convening today on Thursday, May 2nd for the Bryan Kohberger hearing. It will be streamed live on Judge John Judge's Facebook or YouTube. So we're waiting for that to begin. Let me say hello to everybody. Thanks for hanging out during the intro. It's good to see you guys. And I want to thank you for coming here to watch this hearing, because I know you could go a lot of other places to watch this, but you chose my channel. And for that, I thank you. So the way that I like to give back is the wheel spins on the Wheel of Friday. You can see we have our wheel goals. We have met our super chat goal, guys. You are amazing. So that means we are one step away from spinning that wheel. I love you too, Miss Global. It's good to see you. So anybody who uses, since our J4J411.live tip goal is pretty low there, not quite up to the super chat. Anybody who uses www.j4j411.live today gets 2 spots on the Wheel of Friday. If you're not sure how to use that, go ahead and ask a mod. They will help you out. And thank you in advance for your support. We got our plaque yesterday. It is displayed right here. I'm not sure if that's where I'm going to keep it, but we are official. We have our silver play button. So thank you, everyone, for allowing me to get to that point. Hey, Shell, welcome in. W, it's at 1 o'clock. Hey, Meg. Meg P, I got to thank you again last night. She gave 20 memberships out last night. I don't deserve y'all. Melissa B, welcome in. Criminal Med. Yes, Angie B, I hope you're doing good today. I know, Angie, you weren't here last night for the unboxing, but it came while I was live. I was waiting for it. It was supposed to be here before 7. And, Meg, you just threw me off. I'm like, yes, you did. I'm like thinking to myself, that was last night, wasn't it? Thank you, Sage. Thanks, guys. It's pretty exciting. M11, what's up? You did watch the replay. Well, thank you for watching the replay. It was pretty funny. So it was supposed to be here by 7. I went live at 7. It wasn't here. And it got here at like 8:15. And the dog started barking. I'm like, oh my God, I think that's UPS. And it was UPS. And we got the play button yesterday, so it was pretty exciting. Carrie, thank you so much for donating through www.j4j411.live. You just got yourself 2 spots on the wheel, coming in hot with that first tip. Coming in hot, just like the fajita. Jeff Kent coming in hot. W says the CP and Terry Lynn exchange was wild. Dude, beyond wild, right? Sick. Oh no, both of them, Ange, or just my little termite? Hey, Siobhan from the UK, welcome in. Yeah, criminal. I know, I didn't think it was gonna make it, and then the dog started barking. I'm like, I think it's UPS. So welcome in, guys. If you haven't chatted before, feel free to make yourselves known. We are a friendly group, a great community that you have just entered. Please feel free to chat away and get to know one another. We do that a little bit deeper in our Discord. So how you can become a member of our Discord is by being a member or a Patreon of the channel. It's that simple. Kels coming in hot. Just like the fajita. Thank you, Kels. Kels, I got to thank you for this too. Look what Kels made for us. We have our cheerleader, Mr. Chris Proudfoot. Hell no, we won't go. Hell no, we won't go. Or maybe he's doing this. We must increase our bust. What's up, Kristen? Hey, honey. For everybody that's just coming in, welcome in. We're waiting for Judge to open this shiz up. We got about 1 minute till 1 o'clock. It is 10 a.m. on the Pacific Coast. So good morning to all of the Pacific Coasters. Hello, Karchi. Karchi coming clogging in. She's flinging those clogs around.
Flung.
Positive Thinker Helen, hello. Thank you so much, Carrie. Thank you. You guys are amazing. You are. Thank you, Siobhan. Kristen, look, we got our play button. We got our play button last night, y'all. Good morning in South Dakota. Good to see you. Makita, look, we got our play button. Melissa B, thank you so much. You guys, we're gonna spin that wheel possibly tomorrow. Maybe not. Maybe I set my goals too high. I don't know. Chris Proudfoot told me to make my goals that high and he would cheer me on. So he's over there cheering me on, Jammers. Thank you so much for your donation through www.j4j411.live. It's easy to use, y'all. And you get the on-screen recognition. It's actually really fun. I know, Peter Pickle. Isn't that great? I know I missed you. Thank you, She Who Sees. It's no joke. Really, all of us that come out with this play button, I think we come out with like battle wounds, battle scars. YouTube is a very, very, it's a rough place sometimes. Ryan, thank you so much for making sure I ate yesterday. Delaney, thank you so much, girl. Toronto Maple Leaves. Heck yeah. Come on, John Judge. It's 10:02 out there. Yay, true crime. Welcome. It's looking good, Makita says. Thank you, Makita. You guys are the reason for that plaque. Definitely. But isn't it hot? It's like so sleek and pretty. I just can't believe my freaking name's on it. Ah! It's amazing. Thank you so much, Angie B. You guys are just the best. Just the best. So anybody who donates through the J4J411.live gets 2 spots. Our wheel is going to be huge this week. Huge.
Baby D.
Angie B. giving away Delaney. Cat Mama, Criminal Med, welcome. Gen Z. Yeah, definitely takes tough skin for sure. Huge. It's going to be a huge wheel. Thank you so much. Hit it, Baby D. Where is our Baby D? Are you giving away the play button? Hells no. Hells no. John Judges did? I don't see it. Oh, there it is. Finally. Here we go, guys.
Thank you very much. Please be seated. Good morning. Yay. On the record, please.
Shit show beginning.
Thank you. We are now on the record. This is State versus Bryan Kohberger.
He has chat on.
R29222805. Mr. Kohberger is here in the courtroom. He's represented by Ms. Taylor and Mr. Logsden. Also, Ms. Massif is participating remotely. For the state, we have Mr. Thompson, Ms. Jennings, Mr. Nye is participating remotely, and I don't see Ms. Beatty. So
Miss Beatty.
Have a few things just to sort out. today. The first thing I want to talk about is whether or not this hearing should be sealed.
What?
What's your position, Ms. Taylor?
Your Honor, this hearing should not be sealed.
Ooh.
Okay. Mr. Thompson? Ms.
Well,
Jennings?
Your Honor, the state's prepared to do its argument today without actually talking about the specific request that we're trying to protect within the discovery request. And so as long as those specifics are not discussed or mentioned, then I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else is in the public record and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights. So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
It's the challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I hope that you can both honor that at this point, because down the line, maybe some things do have to discuss. We need to discuss very specifically that maybe both sides don't want that out in the public, because it is a fair trial goal here. And if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, gets more complicated and may be prejudicial to one or the other. So I guess at this point we'll keep this open, but be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about. And some of those materials or potential evidence could be prejudicial to the state, or could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance, where when we get to the trial, if we ever get there,
that's funny.
That it'll be fair and we'll have been determined in advance. Okay, so keep it open today. If something comes up and we need to close it down for a period of time to discuss a particular situation, then we can do that. Okay, so it really, I think at this point, it's the state's motion to close the hearing completely.
Of course it is.
On May 14th. I believe,
Thank you, Angel.
not incorrect, that you both have stipulated to closing May 16th, which is related to the IGG.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the materials protected by the court's order, and so that one's appropriate to close.
Okay.
I know,
I think I'm
Carrie.
on the same page, but great. Okay, Ms. Jennings.
Thank you, Judge. So, Judge, the applicable authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124. Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing. Feel confident that when the court does this same balancing test, it'll come to the same conclusion. For the record, since the beginning of this case, attachments detailing the specific discovery request have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's fourth and fifth motion to compel discovery. Concurrent with the defendant's fourth motion to compel discovery, the defendant motioned the court that the details be filed under seal, citing Rule 32. Concurrent with the fifth motion to compel discovery, both parties stipulated to filing the details under seal, citing Rule 32 as well as Idaho Code 74-124. So the state followed course. We have filed all of our responses under seal and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position and asking the court to ignore all the previous filings. And this is just entirely inconsistent.
What?
To be clear, the state
It
has
is
nothing
kind
to
of.
hide. However, it's crucial that we protect, as we have been trying, the integrity of this case, and that we protect, ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for a defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-104, subsection 2. What they specify as subparts B through N, all of those items discuss evidence related to this investigation, of which disclosure would, 1, interfere with enforcement proceedings pursuant to 74-124, subsection A,
Who said that?
deprive the defendant a right to a fair trial and the state, subject to 74-124, subsection B, and Rule 32, subsection E. And it would disclose investigative techniques or procedures which are exempt, pursuant to 74-124, subsection E. For defense's fifth motion to compel, Item 1, subparts A through J, all deal with the investigation. All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject to 74-104, subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I to A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32, subsection 3.
Welcome,
Subpart
Angel.
N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, Subpart A, names a private business and is exempt under the previously cited authority. Item 2, Subpart B through L, deals with the investigation, again exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A.
Ooh-wee,
And
that will
3.
scare somebody.
Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in the media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's 4th and 5th motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you.
Oh, she ready.
May 3rd might be a little quick.
May 3rd?
Well, Your Honor,
Tomorrow.
right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Okay, thank you. Thank you, Ms. Daniel. Ms. Taylor?
Is it tomorrow?
Thank you, Judge.
Here we go.
Our discovery requests have been filed for months and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Ooh.
Can I just add,
Oh.
because I've read through all of the 4th and 5th, and it's, I mean, some of the information it seems anyway. I mean, I'm not. It's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those 4th and 5th, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
Which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean and some of the ins and outs.
Yeah, you already have a closed hearing scheduled.
But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we file those under seal for expediency in saying this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we file those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimbley and State versus Olivine, and they refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Bryan's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider this, that this isn't the state trying to protect Bryan's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context, but that's what they're doing. When they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us, that is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Bryan in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent.
Look at the
Your Honor, Bryan is
prosecutors.
innocent.
Look at them.
And he has an
Dude.
absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Thank you, Ms. Taylor. You know, I don't know where to stop though. I mean, if we start pulling out all the potential evidence for the trial, before the trial, then does the state get to respond to that? And that's where does it start? I mean, or stop. It just is a roll of that. And so either side, okay, that it sends to the public that it is not, you don't get the context. They don't have the context, the public. You have the context. You want more context. I get that. But it's really difficult to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Kohberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to, if you want to answer that.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. We want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I would say both sides have said in their motions or in their briefs that they've disclosed, certain things, and it's a change. See that because both sides have agreed to seal a lot of these issues of evidence in the discovery. And so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like, this isn't about discovery, this is about the hearing.
Your Honor, those are discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about. And these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that needs to continue to happen. that there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine. And I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. Public has a right to see how its business is carried out. My interest is Bryan's right. But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 in the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider too how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Bryan has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Ms. Taylor. Response, Ms. Jennings?
Yes, Your Honor.
Here's Miss Jennings
Ms.
again.
Taylor's argued, and multiple completely false narratives are the exact reason why this hearing should be closed. Yes, defense has a right to
Look
a
at his
public
face.
trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial. But we shouldn't be discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media. The case law that the defense relies upon has not extended this balancing test to these types of hearings. The hearings are about, or the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure gives you this balancing test. We just went through the balancing test, and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel. However, at that hearing, this is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request, and it had to do with training records. That is not what we're contemplating discussing at this hearing on the 14th. I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you.
Want to respond to any on that, Ms. Taylor?
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us. And we've abided by that, and we understand that. But the entire hearing leading up to that was done in the public eye.
Right.
In that particular hearing, they talked a lot about DNA results on a knife sheet. That I'm sure benefited the state to have that in the public eye. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names. I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of.
That's the thing. I don't want to talk about those particularly. And
What just
I
happened?
guess I'm reminded, okay, in your comment about the IDG, because once again, I'm in this position where I have to make decisions blindly to some degree, and that's what the case with
Why
the
is it
IDG.
blindly?
I mean,
You should be able to see
go
it.
through all of that
It's your job.
information, and then I provided
What's on his hand?
most of the information to you, okay, to the defense, so that you could evaluate that. I feel that the same way about there's a lot of stuff, okay, that you're arguing about and the state is arguing about. And I think it's complicated to just open that up. I think that, maybe we could go through a closed hearing and then open up what you feel needs to be opened up. But I can't make that decision in the abstract. So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of issues, Your Honor. I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents and the CAST report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas, deuces take them to the FBI.
What?
I mean, it's really difficult to get information from the FBI. You know that. They know that. I know that. We have we have to jump through a bunch of hoops to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that. But that is one of the things that, we can maybe address that today too. I don't think, thinking that you don't have an objection for me to sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I can sign that today.
You can sign that. You can sign that. Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm trying to do that, and
Nothing is funny,
from what
Judge.
I've seen, I think the state is trying to do that. I know that it's not satisfactory from your position, but there's a lot of issues in this case.
And Your Honor,
That's not
that's
good.
really a lot of what we're going to talk about on the 14th is the timing of these things,
Right.
not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do. And when we make a request and months later, you're asked to sign the order so that maybe we can finally get that information, that timing part is important for the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial. That is fair game for the public, and that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for 1.5 years now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay, thank you.
Oh, Lord. What's he going to do? He's probably going to close it.
I mean, are you expecting to make the decision right now? Maybe not.
Yeah.
Well, Judge, you should just make the decision to have the hearing open. And
What
if I
the
start
fuck?
to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed.
Why did-
I don't agree any part of the hearing should be closed. And I think you should make the decision now. We're 2 weeks away from this hearing.
Oh, 2 weeks? Is that right? 14 days?
We're less than 2 weeks. We're 12 days.
Is he an actor?
All right. Well, I kind of mentioned this a moment ago. I just feel like we need
What you
to
are witnessing
get
is
into
real.
the details, okay, of all these issues before I open it up.
I know,
So
by you,
I'm
it's
gonna,
messed up.
close that hearing. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you aren't getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI, and that we need to get that. I mean, those are all really complicated processes. And I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it.
Wow.
But I need to dig in, and you all need to dig into exactly what is the problem with each one of these issues. All right, so let's talk about
What's going on?
the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now, you had another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will put an order out, schedule order for providing. I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect.
Right.
And this is related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be
Oh my
witnesses on the
God.
14th too, as well?
Yes, Your Honor.
Okay.
What you are
All right,
witnessing
so
is
let's
real. The
let's make
participants
it
are not
May
actors.
7th for disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that, and we'll have a response maybe May 10th. Is that sufficient?
That's fine.
It's tight.
Well, that gives us 3 days to respond.
3 days. Yeah, that's right. Well, May 10 is I don't know when I'm gonna read all this stuff too, because it's 14th, so if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th. But also, the defense needs some space there too. And I don't think we want to push out that hearing. Can't do it by the 10th.
We have no idea what the defense plans
Right.
on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with the 13th then.
Yeah, I mean, we can try, and then if we
Okay.
need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm gonna have really more, I'm gonna need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay,
I don't expect there to be reports.
exhibits.
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, timeframes because we also have other things to do, but Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us
Oh,
to
here
get
we
a list
go.
of witnesses with no idea what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay, well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, or whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge, and I guess we've said it before. It is more important to do it right than to do it quickly if we have to have a trade-off here. And that includes fairness to everybody involved, including the court.
True crime.
And I would prefer that this not be kicked off, but we're realizing that we're 2 weeks, essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say. And then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. I mean, how many witnesses are you expecting to have?
Your Honor, I'm expecting to have 2 on the 16th. At this point in time, I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already.
Exhibity.
There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses on that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Thank you. Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you don't have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff so that we can get ready for the trial.
Well,
What's so
and Judge,
funny?
I do, for the record, need to clarify the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what that they felt they had to file a motion to compel on, instead of being patient and wait because our discovery deadline isn't until September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts, as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas ducis tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, many of the things that the defendant has tried to itemize, when we talk to our people, they say that doesn't exist. So, I don't know what we're supposed to do at that point, and we'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or no, we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of it.
Thank you, Your Honor.
Your Honor, I want to respond to that.
Holy.
And I can give you particular examples of things. And it's already been ordered to be given to us, the CAST report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things, Your Honor.
Oh,
That's
This
there.
is fucking awesome.
Let's not go there. I mean, we can sort that out on the 14th. I mean, I read everything. That's what the state was saying. I trust both of you, okay? Your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. It started at the last hearing, and I really want y'all to just tone it down a little bit. I mean, you can argue all you want, but when it starts to be personal, it's destructive. I mean, you're really, really good lawyers. So let's just focus on the issues. That's
Your Honor, we're happy to. And when we get the CAST report, we'll disclose it. If we do not have it, we are not withholding it. As simple as
I
that.
read that last night. Okay. I'm very prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand, and I understand your frustration.
What about the
and
family's
it's a big
frustrations?
deal.
Come
It's
on,
It is a
really
big deal.
important.
move the shit along.
I understand that too, and I acknowledge that. Sometimes, we just can't quite get what we want from other people who might have it that don't want to give it up. So that's one of my challenges on the 14th and probably at the 16th too. Okay,
Okay,
moving on.
am I expected to make a decision?
We've got
No, Judge. You're just the judge sitting at the bench. You're supposed to let them make the decisions.
all right. Some of these pending motions. There was no request or no response from the state.
Oh,
And I'm
great.
thinking that the motion to unseal parts of the IGP materials and motion to allow defense investigators to review the IGP materials that we're going to be addressing that on the 16th. Is that
Yes, sir.
that's the state's understanding, Ms. Taylor?
Yes, Your Honor. Well, we're happy to have a hearing on the 16th for both of those issues as well.
Great. I'm just trying to make sure that we're all on the same page, or at least the same date. But I wondered, okay, there's been a response on the alibi issue, and I don't know if
Oh, the
there
alibi
is
got
a
flung.
request for a hearing, or if we just kind of let that lie for now. I don't know. What was your intention there, Mr. Thompson?
I think at some point we're gonna need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Come on.
Okay.
If the court would like to select date while we're together today for a hearing, we would be happy to.
Why don't we just wait
That
until the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything, Ms. Taylor. It can read your mind sometime, maybe not. All right. Okay, I'm going to sign those subpoena deuces taken. The FBI. I believe that's related also to the 13th supplemental.
He doesn't even know what he's ruling
I'm
on.
losing track of it.
Your Honor,
Well,
it does relate to one of our discovery requests, and I'm sure one of the numbered motions to compel.
Oh my God.
I'll note that when I speak about that on the 14th.
Okay, great.
Stargazing. I
All
know.
right. Are there any other issues that we need to address today? Mr. Thompson, Ms. Jennings? Okay, Ms. Taylor?
Yes, Your Honor.
Okay, go ahead.
I want to say this in a way that doesn't come off finger pointing, because it's not. This is about how busy everybody is and how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week. And the court could vacate those hearings if neither party notices something up for that hearing. There would be 14 days notice for either party if we have hearings on that basis. But that way we could notice up specific hearings and just have those set dates so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for a hearing and waiting to find that out. It would speed things up to have 2 times a month that we would know.
Yes.
If I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's our request, is that the court just preset a couple of hearings. These would not be like the lengthy motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right. Thank you. I actually mentioned that, I don't know, one of our hearings. That's what we need to do. I think it would be more helpful to, I guess,
have better communication, okay? I don't know, maybe you are having good communication, with each side. It is hard, to get a hearing when the clerk has to contact you or contact Mr. Thompson, and this goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases, and I have a lot of jury trials going from here really to the end of the month. So it's hard for me to say, okay, we're going to have it I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that. I might just set like once a month, maybe, and then if you need something more, just let us know. But I'll look at my calendar and
You should have it with you.
set that up. I mean, I know you come down on Thursdays generally. So that's a good day for you, right?
Thursdays are fine, Tuesdays are fine, Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make that work. I just think it's more important that we have a place to put these hearings so that
This is
everybody's not
ridiculous.
spending a lot of time asking each other what day's okay, what time's okay, that we just
Yeah,
all
just
know that
set
this
it.
is the time. So whatever day works best with the court schedule, Your Honor, is just fine with me.
Thursday afternoon is probably,
That'll work.
Monday is impossible. So what do you think about that, Ms. Jennings?
Yeah, but makes sense. I think Thursday afternoon would be fine for the state.
Do you think twice a month? It's probably gonna ramp up.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. This is why I suggested that, and to know that we have those to iron out issues that are going to arise. Again, these aren't for the motions to suppress, those will come later.
Okay. Maybe we'll start with twice a month to get through all this discovery. I hope we can all get past that soon. And move forward a little faster. Okay, anything else then?
No, thank you.
Okay. Okay, great. Well, thank you all.
That was it?
And have a good day. Beautiful day. Thank you.
I don't even know what to say about these hearings. They have an open hearing and they started out with, should we close it?
You're what the French call les incompetents.
I mean, we're done. They're done. What do you guys think? Can you imagine? Yeah, right. Can you imagine how pissed off the Gonsalves family is? Oh my gosh.
And you know what I have to say to Ann-C. Taylor, the defense lawyer? Bring it on, woman.
She's bringing it on, and it's delay after delay. And I don't know if the state is like trying to counteract like the games or what, but it's horrible. It's horrible. Did they even accomplish anything today? No, because I think they accomplished once a month hearings tentatively on a Thursday. I don't think they said what Thursday, but Ann Taylor was like, we want to do twice a month meetings that are preset. And then the judge was like, well, then we got to get in contact with him and make sure they're all available. You don't have to do that. If you pre-make them, why isn't this case on the first of their list? Like, how many other cases are they working on at the same time? And I've never seen them like push it feels like, anyways, I don't know if this is what they're doing, but it feels like to me like they're pushing this death penalty case to the side and they get to it when they can. Thank you for being a member for 31 months, Alabama Rose. Crazy in the sauce. Get a calendar, dude. Poor fams. I know. What else could they be doing? I mean, usually with the amount of money, too, that this is costing the taxpayers, these ridiculous hearings are a waste of time and resources. Why not just have pre-scheduled meetings where they bring their issues and then you don't have, he's like, well, then I've got, a file, you're saying this and you're filing that and he's filing this. You wouldn't have that if you all got in the same effing room and discuss the issues so they wouldn't have to file all the motions. I mean, I'm not a lawyer, but damn, we follow enough cases where we can put the basics together. It's been a year and a half. I know. I can't even believe it. And now they still have hearings for the change of venue as well. So not only that, we don't even know if it's going to be moved from Latah County to another county because they have to finish their surveys now. And then they're going to have another hearing, I think, in June. So we won't even find out for another month or so if that's even, what's going to happen with the venue. Oh my gosh. Thank you so much, Kels, for donating 5 memberships. She just gave 5 people a key to our Discord. Thank you, Kels. You're awesome. Hey, you, Blonde Appetite, if cats had thumbs, G of Twins, and Upstate New York. Welcome in. Welcome in. Thank you so much. That's so generous. Oh, man. So let's talk about something a little more positive. Because this is what we're going to do here on our channel this year. We're going to celebrate Maddie May Day here for Maddie Mogan. On May 25th, 2024, which is in 23 days, we are going to celebrate hashtag Maddie May Day. So I haven't come up with my full plan yet. It's still in the works, but it's going to include all of you and this hashtag and our Facebook group. Okay. So we're going to make this hashtag all Maddie May Day on the 25th on Facebook. So, I want to make it something special. Like if her dad would come across it, he would see it and know that we remember Maddie. Because I think that's what's so important. Especially with all these games. It's so icky. It's so icky. So let me read to you what they said about Maddie. Maddie dedicated her life to spreading joy and kindness to everyone she met, warming every room with her smile and beautiful presence. She was taken from this world far too young. Just as she was verging on college graduation and beginning her venture into adult life. We all ache from the loss of Maddie, and we ask you to join us in continuing Maddie's mission by completing random acts of kindness. We can't wait to hear the stories that emerge as we all remember Maddie on this day and every day. Happy Maddie May Day. Happy birthday, Maddie. So that's going to be for May 25th of this year. Thank you so much, Jess. 5 more memberships coming in hot. We are just building this community.
Coming in hot, just like the fajita.
Like the fajita. So, everybody think of something that you would like to do for Maddie May Day and start thinking about some random act of kindness that you would like to do, because we're going to share those. We're going to share those on Facebook. I know Maddie was beautiful. And I just love her dad. Her dad just, something about that man, he really just emits nothing but love for his daughter. Welcome, welcome, Melly, Ida, Danette, Val, much deserved. Missy RN, thank you. Thank you again, Jess. It was very generous. Oh, I know. Don't you just love him, Kels? So that's what we're going to do. So you have a couple weeks to think about something special that, I don't know, maybe you've noticed someone in your town, or, you know, maybe you're going to pay it forward at Starbucks when you're getting your morning coffee, or maybe you're going to be at the gas station and say, hey, you know, I'll get the guys behind me snacks. You know, buy someone some snacks. Do something nice for somebody and start thinking about what you're going to do.
Because we bought snacks because, you know, he's 15 and snacks.
So some news. We did a members only live last week. It was the first one we've done in a long time. So we're going to start doing those once a month. So if you just became a member, you will be a part of those. Ours this week last week rather, was on Chris Watt's house, the new, owners, and the drama that has ensued in that home since they've lived there in, you know, like one short year, a little over a year. So I'm going to release that to the public today at 5:00 Eastern Standard Time. You'll be able to see that. And then we are live tonight with Daybell highlights. Also, this Saturday, we have our watch party in Discord at 7 p.m. Eastern. If you're a member, come on into the Discord. If you don't know how to get in there, ask a moderator. Leave a comment in the comment section below. We'll help you any way we can. All right? So be thinking about Maddie May Day and what we can do and share. And you guys can post what you did and hashtag Maddie May Day. So that'll be something really special that we can do, something that's free to do. And everybody can do it. I mean, you can even, if you see your neighbor outside, you can, you know, tell them they look pretty today. I mean, anything. I mean, who doesn't like hearing that? You know, you look wonderful today. You look nice today. Or I hope you have a great day. Anything. All right. Well, I hope you guys are excited to do that. And I hope I see you tonight at 7 for some Daybell highlights. They're always interesting and funny. See, Lisa? Make every day Maddie May Day, but we're going to make Maddie May Day, her birthday, very special here at J is for Justice. And thank you for all your kind hearts and all of your support for this channel. Say goodbye to Play Button. She's looking beautiful today. And justice for the Idaho 4. Let's stay on this case, guys. Let's run our credits. I'll see you tonight. I love you all. Thank you so much. Be sure to check out my other videos and playlists for more true crime content. And if that's not enough, you can join our Patreon. Don't have a tinfoil hat? It's okay. We'll make you one. It's that easy. See you guys in the next video.
See you later. Bye.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. I don't give a damn. I don't give a damn.
Why is that your sound?
I don't give a damn. I don't give a damn. You wanna be,
with them high top white shoes on, with the real hard bottom.
You're making plans to get to France, but don't wanna face the fact
Want to talk about?
Is it one Jennifer or two Jennifers?
Thanks so much, Jennifer.
Jennifer loves horses. Bye, Jennifer.